Imagine that you have an uncontested divorce. We get many calls from clients who think that their divorce is uncontested, and they may agree on some very important things in their case, such as who should have primary physical custody and what parent is going to pay child support. But they don't agree necessarily on the details, on the day-to-day schedule for those children. They might not agree on who's going to have Christmas Day, who's going to have Thanksgiving break. They may think that they have an agreement in principle on child support until a child support worksheet is drafted, and it appears that one parent is thinking they were going to get $500 a month in child support when the worksheet is asking for $1,100 or $1,200 a month based on the party's income.
So uncontested divorces are a huge part of any family law practice. And what the clients should really, in my opinion, be looking at is, the value added to having an attorney assist you is that we customize these agreements. Because I often have clients who will come in and say, well, we agree. We've worked all this out. We are on the same page. I don't see a need to spend a bunch of money having a private attorney draft a lengthy document. Can't I just go to LegalZoom? And the answer is that you can, but the reason to hire an attorney is that we tailor the document to you, to your family's needs. And, oftentimes, I meet people who are at the time of their divorce really getting along and in a great place. And for every client I have, I hope very much that you stay in that place forever. But the reality of, my job is that that's often not true. And so if you have an agreement at the time of your divorce that is tailored and detailed to your needs and to your specific situation, it can help you as you go forward to avoid conflict. Because if the drafted documents, whether it's a parenting plan or financial arrangements, if they are detailed enough, they can help alleviate problems down the road. It's often the case that people will be getting along at one point in time, and then as years go on, things may change.
Another issue that we come across very frequently is the issue of property division and what is in fact marital and what is not marital. And so Georgia has all kinds of rules that can be argued on what is a marital asset. And a lot of the times premarital assets come into play where the parties don't agree on what the value of an asset was before the marriage. And so say you have a house that was purchased 2 years before the marriage and you have been married for 10 years. A lot of the times people will just say, well, it's all 50-50. And that might not be the case, because if the house was owned 2 years prior to the marriage, there's some portion of that that's premarital. And people have a hard time agreeing on what that number is. And if you don't agree, then your case is not truly uncontested. Sometimes parties work together to try to resolve their case, and when alimony is an issue, they might agree that one parent needs alimony for a certain amount of time to get back up on their feet. So say you've had a stay-at-home mom and a working dad, and you've been married for 10 years. The parties might agree that the wife will get alimony for some amount of time, but when it comes down to drafting the agreement, they have a very different belief on what that amount of time is and what that amount is monthly. So simply because you agree that one spouse should get alimony and the other spouse should pay alimony, you may not agree on what the fair amount is. And if you're not in full agreement on what that amount is and how long it should be, then the issue of alimony is not resolved.